the child is already abusive in nature, Your Excellencies. And according to also the Constitution, Article 2, Section 2, we are also bound to international law, Your Excellencies. That means, Your Excellencies, being signatories of the ICCPR and the UNCRC, Your Excellencies, we are obligated to outlaw such acts that may pose a risk to the best interest of the child, Your Excellencies.
It's not by your sovereignty, right?
No,
You're
Your
saying that there is international whatever mandated to adopt whatever.
Your Excellencies, being a signatories to these conventions signifies how we concede to actually adhere to these conventions and the rights that are infatuated in such laws, Your Excellencies.
That is not the problem.
Your Excellencies, states are obliged to refer to these and also to acknowledge these laws. So, in light of the best interest of the child, according to the UNCRC Article 17, it is always to ensure the protection of the child. And according to the General Comment Number 7, which is now General Comment Number 20 of the ICCPR, it was stated that as a form of the corporal punishment must be in the scope of torture. And according to the ICCPR Article 7, Your Excellencies, such torture is highly frowned upon.
Yes, Council, you stated that corporal punishment is tantamount to torture.
Yes, sir.
And in your memorial, you cited the case of Osborne versus Jamaica, Suflal versus Trinidad and Tobago. Can you brief us as to these cases and give us the factual scenario?
Yes, Your Excellencies. According to these cases, Your Excellencies, these were all cases about child abuse, Your Excellencies.
What is the extent of the abuse that was committed in these cases?
Some of these were judicial abuse wherein the child was subject to some sort of, as I remember, Your Excellencies, some sort of virgin or whipping, Your Excellencies, and chastisement, Your Excellencies. And that the court ruled, Your Excellencies, that such corporal punishments would tantamount to torture as defined by international law.
In that regard, how would you address the submissions of the applicant when they said that, well, we could allow corporal punishment, but we could limit it in such a way that it would not reach such points?
Your Excellencies, as I stated earlier, putting a standard would still be conceding to violence against the child, Your Excellencies. As I said earlier, Your Excellencies, abusive punishment starts at the very instance of ordinary physical punishment, which escalates to a greater form of punishment. As said by the Institute for the Prevention of Child Abuse, Your Excellencies.
Are you aware that there are laws that protect the child and other disabilities? It may be a question of implementation of these laws rather than enactment of the laws.
Yes, Your Excellencies, but the respondent says that these laws are not enough. Because if these laws were enough, Your Excellencies, there wouldn't be the existence anymore of the DSWD, for instance, or the Women and Children Help Desk, or at the very least, Your Excellencies, these updates by the DSWD of the increase of child abuse would at least lessen, not add 51 cases, Your Excellencies. That only shows that there is a trend in Philippine society that already says that that corporal punishment should be extinguished, Your Excellencies. And there is a recent jurisprudence case, 2004, People versus Ayuman, wherein a little boy named Sugar Ray was accidentally killed by his father by inflicting corporal punishment. And the father has been inflicting corporal punishment towards the child for how many years now. And it finally escalated to an extent where the death of the child was produced.
Last question on my end. Assuming that there is a model parent who for 20 years has never laid a finger on his or her child, and then in the heat of anger, one moment where he was really angry, he decided to give a playful, not really playful, but like a light slap on his or her child on the cheek. So that person will be subject to prosecution under the corporal punishment law, and you're going to send this person to jail.
Yes, because, Your Excellencies, it has to be considered that these are stepping stones, Your Excellencies, to what can escalate. If you permit one act of abuse, one act of violence, then you're also permitting, Your Excellencies, succeeding acts of abuse, Your Excellencies.
In the example you gave where the parent abused the child, the point of my colleague here being that was that not that act of the parent punished under prevailing law, where the parent imposes corporal punishment and resulting in death of the child, isn't that punishable under present legislation?
If it only results in the death of the child, Your Excellencies, but there is no law as of now, Your Excellencies, which actually punishes or bars parents from inflicting corporal punishment. There is only a bar of corporal punishment to people who exercise substitute parental authority, Your Excellencies, as found in the family code. But there is no prohibition to that of parents, and that is what the respondent is trying to invoke, Your Excellencies. Full prohibition, regardless whether it be from the parents or people who exercise substitute parental.
That's correct, but the point being there are already safeguards against abuse,
Yes.
against reasonable corporal punishment.
Yes, Your Excellencies, but it cannot be denied that these laws are just not enough. Because if it were enough, Your Excellencies, then there wouldn't be an increase as stated by the DSWD in cases of child abuse, especially at home, Your Excellencies. So as long as these updates by the DSWD does not lessen, Your Excellencies, and given the recent jurisprudence, Your Excellencies, the state must not stop in trying to protect the best interests of the child. As a closing remark, Your Excellencies.
Okay, I think your time is up.
Can I just have one sentence? Your Excellencies, respondent concedes that children need to be disciplined. However, we question the way children are disciplined when it comes to physical punishment, when there are other alternatives that the state can promote and parents can venture into that will be in line in doing the best interest of the child. Thank you, Your Excellencies, and may it please the court.
Thank you, Councilors.
Mr. President, Your Excellencies, good morning. My name is Carmina Guevara, Second Agent for Respondent against Corporal Punishment. My co-agent has early on established that 1, corporal punishment is indeed an act of violence against the child and their rights, and 2, that corporal punishment needs to be banned in the Philippines as a necessity to adhere to both domestic and international law. As Second Agent, Your Excellencies, I am now asked to present to this Honorable Court our last 2 submissions for the respondents. 1, respondent submits that there are indeed alternative measures available to the parents in disciplining their children without the use of corporal punishment. 2nd, respondents propose means of implementations for these alternatives. If there are no preliminary observations, Your Excellencies, I